Hey, young people. Well, grab a cup of coffee or drink, and we're going to talk about this search warrant in detail. So they've arrested a guy that sold Stephen Paddock, the shooter in the Las Vegas shooting, ammo. And they arrested him because he sold him tracer ammo, which is legal ammo, which is military produced. But because they found his fingerprint on one of the rounds in one of the magazines that they seized at the crime scene, that's how they arrested the guy that sold it to him. Now, the warrants I'm going to go over are not the warrants on this guy they just arrested. These are the beginning warrants right after the shooting, and they kind of tell a story that the media hasn't told, and it gives a lot of facts for the first time that we're getting true facts, in my opinion. So let's take a look at these warrants. Okay, so I've talked about warrants before, and again, remember, most cops, and I say most, I'm going to say 90% of most cops have never written and will never write a search warrant. There's a small percentage of the cops that write search warrants. Most of your guys on the streets don't, unless they promote to detectives and start doing serious investigations or investigations where they need to get a search warrant. Most cops on the street. So for me, I say a warrant is very easy to get because I've done so many, and it's second nature. And cops that work to where they write a lot of warrants, they're very easy. But it's a complex kind of list of details that you have to get together and you have to learn, and there's a learning process. And when a cop does his first warrant, I mean, we could take 6 to 8 hours to get a warrant. A cop that's done a lot of warrants may be able to get a warrant in an hour or two. So this number right here is SW17-97A. Each agency has their own way of doing warrants. This is search warrant, meaning it was written probably in 2017. And 971A, where I worked, would be that's the number of warrants that's been requested in that county. So there's been 971 warrants. I've written warrants at the beginning of the year where it was search warrant, 2001, and the number was 0003, and it was the third search warrant of the year. So I'm thinking this is the 971 search warrant that they've done, because when you do a search warrant, you have to get it numbered, so they're all numbered for the courts to record them. So that's what the numbers are. Let's see here. It looks like October 27 was when they stamped it, so or 2017. So it is 17. Okay. So we're going to go through the search warrant here, and it's going to be very repetitive, and you're going to see what's called piggyback warrants, but I'm going to explain the warrant process and the information that is given here that they've been telling the media we can't talk about because it's it's ongoing investigation. Can't talk about it. Okay, so ex parte hearing. Ex parte just means one party isn't there. So normally when you have a ex parte communication, you're doing it without the other party's knowledge, and they don't have input. Their attorney doesn't have the right to say. The court knows that it's giving a one-sided review, so they have to take that in consideration when they're doing something. Most restraining orders are ex parte when they're initial, and then you get a temporary restraining order because it's ex parte, and then after you serve the person, then that person has a right to come in before a permanent restraining order is issued. So ex parte is just a meaning one party in the legal system, so to speak. Okay, hereby order this affidavit in support. And when they put these warrants in, this is the judge's signature. So this is after the warrant's writ. I'm going to move down to where the actual warrant is. So you can see the search warrant here that's signed by the judge is saying the state of Nevada to any peace officer, whatever state. When I wrote these in California, it would say to any to the state of California, to any peace officer. So any peace officer in a state can issue a warrant. It doesn't need the person that actually writes the warrant. I could write a warrant, give the judge the information, have guys standing by the house, and when the judge signs it, I call the guys at the house and say, hey, I got a warrant, you guys can search. And then they can start searching even before I get the warrant there. Now, before we leave, we have to leave a copy of the search warrant and the items that we took with a receipt. And we're going to see a receipt of the items they took, which, again, tells us more information than what the media has been telling us. So obviously they're saying they have probable cause to believe that this evidence is going to be, this is what they're looking for. And in every warrant, you have to kind of put what you're looking for. So they're looking for ammunitions, holsters, firearms, cleaning equipment, basically anything related to firearms. If you're doing any type of firearms search, you could probably copy, cut and paste this. You'll do it. If you're looking for digital evidence, you could cut and paste this number 2. I'm looking for digital and physical items indicating planning, ideology, and pre-preparation surveillance to include maps, drawings, concert tickets, hotel rooms, reservations, receipts picked. So you're covering everything that you could take that could possibly be connected to this crime. And then number 3, all persons located at the prison. Basically, we're saying when we get to the search warrant, we want to be able to search anybody located at the premise, to include this person, Marlo Daly. And I can't remember if that's the guy that did the warrant or what his connection is, but they want to search anybody at the place they're searching, and specifically this person, date of birth. But because a person isn't listing and they've got all persons located, that covers everybody. But if you have more specific information, kind of like on that Nunes memo where they left out information about the connection, you always want to add more information. You don't want to get accused of withholding information that, hey, I really wanted to search this person, Mary Lou. Oh, Mary Lou, I think that's the girlfriend. I really wanted to search Mary Lou, but I'm just going to put all persons. That would be kind of concealing. And then number 4, any and all vehicles at the residence at the time of the service. So, and the reason why we put this in there, or words to this effect in there, is sometimes when we're hitting a drug house and we know there's going to be multiple vehicles there, we don't want somebody saying, hey, I don't live here, I'm just leaving, let me get my car and leave. No. Your car is on the premise, we're searching it, it's in the warrant, you ain't leaving. Because normally they're hiding drugs, dope, indicia, money, whatever. So that's kind of where you get down to what you want to, what you're looking for. And then you're going to get in here, limited items of personal property to which establish possessionary interests. They're saying possessory interests. We call that indicia. If I wanted to put this in here, anytime you search a residence, you want to confirm that the resident you're searching is the residence that you described, or the office building that you described in a search warrant. So you're looking for indicia of ownership or care, custody, and control of that property. So if I search your house and it's your house and I got a warrant for your house and your name and we know you live there, I'm going to want to find indicia when I search that house, such as electric bills, water bills, house payments, credit card receipts, anything that you get mail at that house that establishes you live there, you're getting mail there, it's your house. So that's kind of what they're establishing when they put this in here. Let's see. And again, I'm going to have to read this as I go. I've read it a couple times, but I'm just going to go over it here. Prescription bottles, they're looking for meds because remember they found out that he was on anxiety drugs, so they want to find prescription meds. That will also count as indicia because if I'm saying that Joe Bob lives at this house and then I find prescription medicine in the medicine cabinet that's prescribed to Joe Bob, that helps me establish this guy. Telephone bills, utility bills, receipts, vehicle registration, things like that. Those are just all what we call indicia. And now we have to get to the property of the person's name at the address located at, and here's the address, 1372 blah, 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 in Nevada. Said premises describes single-family home. Normally put single-family, tan in color. You describe the color. The residence has a tile roof. Okay, it's the front door is facing south. Okay, so we know they really want the residence described very particular in residence so you don't, in case I give this warrant to someone else to serve, they're not going to make a mistake and serve the wrong house. I know somebody's saying, Rick, they're always hitting the wrong. Well, they may be hitting the wrong house, but there's a lot of incompetence on why they're hitting it. That's not getting out. If you describe the residence really well, it's really hard to get the wrong house. But I realize it can happen. Okay, so we'll go down the warrant here. You are hereby commanded to search forthwith. That's the judge saying go search and wreak havoc and search and destroy, whatever the judge is going to say when he signs it. All right, so now we're going to go down to application and affidavit for search warrant. So this is where your affidavit is what the officer is swearing to the court. So Kenneth Meade, PD number, that's his probably badge number 5831, or it could be his CAD number, being first duly sworn. Okay, I don't know. Remember, lawyers used to get paid by the word. So legal documents, they like to put in a bunch of BS words. I tried to cut down my warrants. I wouldn't put being first duly sworn. I would just put sworn officer, maybe being sworn. Being first duly, really, is that really needed? No. But legal mumbo jumbo, sometimes it's in a template and people just use it. Cops don't want to think out of the box sometimes. I put all that, I knocked all the BS words down and just wrote my warrants simple because I just didn't see the purpose of it. Okay, deposed, it says, Defiant Huron, detective with the Las Vegas Police Department, assigned to counterterrorism section. Wow, Las Vegas Department has a complete counterterrorism section. I didn't know that. Did anybody else know that? They have a complete section. So the taxpayers of Las Vegas are paying taxes to have a counterterrorism section. But we need to open the borders and, well, I digress. Let me stay on the warrant. Okay. Has been employed for 19 years, been assigned to the counterterrorism section for 6 years. Not only do they have a section, they've had it for 6 years. But, Rick, if we open the borders, it'll be great, and we'll have more government, and we'll be safe. Okay, whatever. There's probable cause to believe that. Now, this is where I'm kind of shocked on this hero sheet. Because normally on the hero, you have to describe your education, your formal training, your informal training, on-the-job training, and your actual experience in order to say that you're qualified to come to the conclusions that you're coming to in this warrant. In order for me to say in a warrant that I expect to find these things at this place, I have to articulate why I believe that. And this is a very one-sentence short, what we call a hero sheet, basically saying what you know, why you know, how you know it, and it gives you more credibility. This section helps get your warrant to where a defense attorney ain't going to come in and be able to turn this upside down. I mean, my hero sheet was, and I've got a couple of warrants, but it has to say, hey, I have an associate's degree in criminal justice. I have a bachelor's degree in education. I've been to so many thousands of hours in training in detecting, drugs if I was working a drug warrant, or explosives, or if I was doing a hostage because I've been to hostage terrorism school, I would put that training in there. And I put all my training and education in there, and then I say I've worked a job for 19 years, and during that 19 years, I've investigated 14 terrorist incidents, and I've conducted over 300 search warrants where I've actually found evidence of what I was looking for in those warrants that I've written. And you kind of paint this picture that, hey, I know what the hell I'm talking about, and if an attorney tries to come here and say, you know what, Your Honor, this guy really didn't say his experience good enough, and you issued a warrant, which is what they could say here. I mean, a defense attorney could come in here and say, Your Honor, this officer only told the judge that he was a cop for 19 years, and he was only assigned to the Carabiners for 6 years. How do we know what he did in those 6 years? Maybe he just did evidence receipts. Maybe he was just the evidence technician. Maybe in those 19 years, all he did was transport prisoners. He's never made his own felony arrest, and he's never written a search warrant himself. This is what defense attorneys do when you try to take shortcuts in this hero section. So when you do your hero section, you need to put all your training that's relevant to the search warrant and all your actual experience, so a defense attorney can't come in and go, the judge issued this warrant without really qualifying or finding out that what this officer said is really valid and accurate. And I think a defense attorney there's not going to be a defense attorney because Paddock is dead. But if there was a defense attorney challenge this warrant, I think he could challenge this warrant pretty good in here. Because I've had people tell me, well, when you said you've done 6 years in this section, what exactly did you do? And when you worked auto theft, how many auto thefts did you actually catch? And when you caught those people, how many actually got convicted? And how many of those resulted in a jury trial? And how many of those resulted in evidence being suppressed because of your actions, officer? I mean, they just riddle you, especially the higher the profile, the more exposure the suspect has. If there was somebody facing, life in prison or the death penalty, you don't want a hero sheet. Oh, yeah, I'm a cop, I'm sworn, I did 19 years, and I've been 6 years on the counterterrorism. That is a weak hero sheet in my book, in my opinion. The courts can change, and the courts may say, you know what, we've changed. We don't do that anymore. We don't care. If you're an officer, that's good enough. but I'm just giving you my experience in this. Okay, so again, they describe the residence very particularly. Again, they describe the property, the firearms that they're looking for, digital evidence that they're looking for, any persons at the premise, any and all vehicles, loaded articles properly to establish identity of the person in control of said premise. See that said premise? I just wouldn't put that. Okay, I want to establish ownership, care, custody, and control of the search location. That's the way I would have said it. It's plain and simple. Instead of articles of personal property, which tend to establish the identity of persons in control of said premises, which items of property would be consistent in part or and include, but not limited to, papers. Okay, so I mean, I did put papers not limited to and affects personal problems. Some of this is just, cookie cutter stuff that people copy and paste in there. When you do a lot of them, I would just shorten it up. Again, that's me. I'm not saying I was perfect or I'm great. Somebody's come here. You think you know? Whatever. I'm giving my opinion. If you don't like it, shut the hell up and leave. All right. Computers who bear the person's name, phone numbers, addresses, etc. Okay. The property described demonstrates criminal offense of murder. MWD. Evidently, this NRS must be some Nevada statute. I'm not sure what it is. Because it's got an N, I'm thinking it's Nevada. If it was C, I think it was California. Whatever. Has been committed. In support of the defiance, existence, probable cause, following facts on 1/10/1/17, blah, 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 Nevada. So here's where we're going to get into the meat to where, remember, officers, when they do warrants to the judge, they're not worried about holding stuff back like they are to the media. So when we get a search warrant, which I think is very critical that search warrants ought to be released, and this judge unsealed this because cops always want their search warrants sealed because they don't want anybody knowing. And government wants it sealed because they don't want, supposedly, their secrets revealed. And they don't want people to know their investigative techniques. Well, that sounds good, but it also creates great a venue for corruption and hiding and lies and the people not getting the truth. So I'm glad this judge unsealed this warrant. And you're usually supposed to have good justification to keep a warrant sealed because a search warrant is a public document. And once it becomes public, anybody can request a copy of it. So all search warrants are public documents. So you can get any search warrant written by any cop in any agency because it's a public document unless it's sealed. And if it's sealed, the cops have to give justification. And they're going to give justification here, and I'll get to that in a minute. So, that they're talking about on Route Festival at so-and-so, Las Vegas Police Department began receiving reports of multiple shots, victims down, tactical entry was made. So here's where they say they went in and they found the guy dead. Las Vegas police officers were able to identify the shots were coming from 32nd floor, room 134 and 135 / He put /. I don't know if that means, to me that's not real clear. I would have cleared that up. I would have put shots fired from room 32, 134. That's kind of lingo that I wouldn't expect a judge to know, and I would expect the judge maybe to go, when you've got 32, 134, what exactly that mean? Well, here he says the 32nd floor, but to me it would have been better rooms 134 and 135 which were connected, or 134 and 135 which had an adjoining room. I would have cleared that up. But that's just me. I'm not saying it's bad or the cop's a piece of shit. Don't think I'm out here trying to crack on a guy. I'm just explaining when you're writing a warrant, you don't want people to have questions. And when I'm reading a warrant and I have questions, that means you didn't make it as clear as it was. And if it's not clear to me, it's not going to be clear to a judge, it's not going to be clear to the defendant, and it's not going to be clear to the jury when you have to explain it and you have to sit there and go, well, why didn't you put that, officer? Were you in a hurry to write this warrant? Did you not think this warrant was important, that you just thought you could put 134 and that we would all know? Are you calling the jury stupid because they don't know what 134-135 means? I mean, things get twisted, and when you write these things, if you've never been in front of a few juries, you need to realize how that's going to read and how the defense is going to be able to try to turn that around and make you look bad in front of a jury. All right, so let me take a drink of coffee here. I got to pause it. All right, took a sip of coffee so you didn't have to hear. Tactical entry was made into the room in order to preserve life under exigent circumstances, and law enforcement located deceased male with a gunshot wound. Okay. So when he says tactical entry was made in room 2 order, he's justifying his room for entry. I mean, with an active shooter, I don't necessarily think you need to do that. But again, he's probably thinking in front of the jury, Why did they make entry? He's going to go ahead and clarify that. Tactical entry was made into the room in order to preserve life under exigent circumstances, meaning we didn't need a warrant to enter the room. We entered under not only preservation of exigence, but to stop people from being killed. And that's why we enter the room. And then once we get in the room, now we want to secure it and we want to search for things. And that's why we're here, Judge, getting this warrant. Because we went in this room, we found a guy dead, and there's ammo and evidence that we think will relate to this, and that's why we need to enter. So he's tying the warrant together. Good, got no problem with that. This says they found a deceased male. Now I believe that they actually found a deceased male, because an officer wouldn't swear to this in a warrant and go under oath and risk his job and career to tell a judge this unless it was true. So all the media about whether he wasn't shot and the conspiracy theory, now that I have a warrant signed under oath by an officer that they tried to keep sealed, I believe that when they enter the room, he was dead from a gunshot. The male was identified as on the driver's license, via his driver's license, as Paddock with his date of birth and an address. So that's how they get the address on here's where we want to go search next, because the guy lives here, he's at a hotel. So this will be, they'll first get a warrant for the room, and they may combine it and say, hey, we want to get a warrant for this guy's address too, which I think they did. And it was confirmed by visual Las Vegas police officer Hancock. So now Hancock's going to have to be called to testify when they go to court. Officer Hancock, according to this warrant, it says you identified the suspect. When you entered the room, did you step on any brass or disturb the crime scene in any way? No, I was very careful not to do that, which is BS because they entered in a hot entry. The answer should be, yes, we were entering in a tactical situation. We thought we had a guy shooting. We didn't clear the room. We didn't know if there was multiple suspects. When we entered, I wasn't caring about the crime scene. I was worried about officer safety. We searched and cleared the premises. So in that time when I was moving around, I may have disrupted the crime scene. I may have stepped on a shell. I may have kicked a shell. I may have kicked a gun. I don't actually remember. It was a high-risk situation, but I do know that we were looking for multiple suspects, and until we secured the room, I was more worried about my safety and other officers' safety than I was about the crime scene. That would be a legitimate answer in court. Now, officers sometimes get caught up in court, and they start trying to, oh, if I say that, I may look bad, and it may look like I don't care. And you know what? Just say what it is, people. Say what it is and let the chips fall. I tell cops that all the time. Don't get into trying to guess where the defense is going or play the game or outsmart the defense or outsmart the jury. You know what? It is what it is. Let the chips fall. If you look stupid, you know what? We all look stupid once or twice. We're all going to look stupid again once or twice. Let it go. Don't try to second guess. So inside the room, law enforcement further discovered multiple firearms in close proximity of the body of Paddock. Preliminary investigation indicates Paddock was subject involved in firing at the above described concert venue. All right, so I know I'm talking fast, going fast, but hell, I'm already at 23 minutes, and we're not even 1/4 of the way through this search warrant information. There's a lot of information here that I'm trying to get out. If you want to watch it, great. Please don't come here and cry about how I'm long-winded and talking. I'm telling you, it's going to be a long. This is a huge search warrant on a huge incident with multiple dead bodies. And there's a lot of things behind the scenes that most people won't know. And some cops will want to know it. Some people that aren't cops will want to know it to understand the system. Hell, there's some lawyers that will probably learn from this video. So if you want to learn, then hang around. If not, shut the hell up in the comments. Get the hell out of here, you big pink panty crybabies. Rick, why are you being mean to people? Shut up. I don't want to hear it. All right. Security investigation purpose follow-up. A check of the room registration, Mandalay Bay, indicated that the room was registered on September 29, 2017 to a Stephen Paddock, blah, 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 give his thing. A Players Club card in the name. So Mary Lou, his girlfriend, had a Players Club card. So what this guy did is he probably used her card to give her points, etc. Was also located in a room. So if her card was in the room, it either, in a cop's mind, when I'm writing a warrant, either she was here or she has multiple cards, or he's using her card. But again, that ties her in the web of a possible co-conspirator. So she's obviously a person of interest, maybe not a suspect. A suspect would lead me more like I have really evidence that I think she's involved. A person of interest is more maybe, I mean, it's still a suspect to me, but it's not as high of a standard, I would say, that I really think she's connected. I just know she's somehow involved. So somehow her name's there, her card's there, she's involved. She's at a minimum person of interest, if not a suspect. Okay. The room address returned to this, Nevada. Let's see, contacted Mesquite police. So because the address was in Mesquite, they contact Mesquite police and had a surveillance quest. Now, what we would call this, sometimes we make an entry to secure a residence. If I know I'm doing a search warrant here, and it's an ongoing investigation, which I think a conspiracy or criminal conspiracy is still ongoing, and I still think parties may be either gathering evidence or continuing conspiracy or moving evidence, destroying evidence, I want to lock down this address. And I can't lock it down or search it until I get a warrant, but I can lock it down as soon as I'm connected to it. So the second that they find her name in this place, they have the authority to lock down under exigency. I know that my constitutional people will be here. According to the Constitution, you can't invade somebody's privacy without a warrant signed by... Yeah, whatever. Okay, I'm telling you. Supreme Court's ruled about exigency. We can do exigency. I know it's abused by some cops, but in a situation like this house needs to be locked down in Mesquite to make sure that people aren't in there erasing computers, destroying computers, removing computers and digital evidence, removing ammunition and guns, removing their planning, removing maps. We need to make sure that nothing leaves this house until we get a warrant. And the courts of rules, it's reasonable to lock down a residence while you're pursuing a warrant if you think that evidence in that residence may be destroyed. And it's very easy for any officer with any experience to indicate or justify on how, when we do multiple drug arrests or large investigations, as soon as the parties know that the investigation and people are being arrested, people get in jail, they call their friends, the news media releases information, and they know that we're on hot pursuit, therefore they start destroying evidence. So to lock down this residence, we made a call to the Las Vegas unit, Mesquite. A surveillance request was initiated at approximately 20. The house was locked down with no apparent movement in or out of the residence. It sounds like they just put it under surveillance. I would have went one step further and said, I want you to make entry. I want you to make sure nobody's in the house. Anybody in the house, I want them detained and identified, and I want to make sure that nobody's hiding in that residence, destroying evidence, setting up bombs, waiting for us to make entry, etc. I want immediate entry in that house, and I want to confirm that no evidence is being destroyed. It sounds like they went less and just put it under surveillance. I would have had units do entry, but that's me. Let's see. An emergency administrative subpoena was requested from the Water District. Evidently they have, and I mean, we've used administrative subpoenas. Only investigators at the DA's office could issue it in our county. Most cops can't issue it. Usually the DA's office is the only one that can issue a subpoena. A subpoena is basically a court order. It is the same thing as a search warrant, but a judge hasn't signed it. Court officers at the district attorney's office are allowed to subpoena things once charges have been filed. Now, I don't know how this emergency subpoena, administrative subpoena works in Las Vegas because each state may be different. In California, we would get a preservation letter or say, you know what, preserve this, or give us this information now and we'll send you a warrant later because we have an ongoing criminal crime and people are in danger. And then this would be released pending a search warrant later, because just giving us information about the Water District on who confirmed is not what the courts would consider invasive. It's not like we're searching a woman's vaginal area because we think she has drugs. We're merely getting a water bill from the water company saying who lives there. So that's not real intrusive. It's very easy to use exigency in order to get that information without a subpoena or warrant and say, hey, give us the information now, we have exigency, and we'll give you a warrant later. And then we give them a copy of the warrant later after we do it. And usually most government agencies, water districts, electric companies, phone companies will give us that information as long as we tell them lives are in danger, there's an ongoing emergency. Then we can get it without the warrant. Other than that, we need to give them the warrant first. In this case, I think they had more than enough to get it before they got the warrant. Okay, so here we go. We're at 30 minutes. I want to keep going, people. It's a long warrant. It may go an hour and a half, but we'll see. Let's see. Customer name, Paddock, given multiple sources, information indicating most current address for Paddock, specifically his Nevada driver's license and player card, etc. So they're confirming and they're tying his address. In this little paragraph here, we want to tell the judge, look, this is why we want to search his address and we want to search her address because they're connected. They live together. We know they live together because of the water bill, the electric bill, the Nevada, the player's card. So we've tied it all together and we've made more than enough probable cause to say, you know what? We have reason to believe we're going to find evidence and these people are connected to this crime. They've killed a lot of people. We need to get in there. Okay, while monitoring and identifying the Facebook accounts, so he really didn't say that we started monitoring, but it's kind of implied while monitoring the identified Facebook accounts, which basically means as soon as we found out names of these people, we started monitoring their accounts. So while monitoring the accounts for Mary Lou on a Facebook, and it gives her Facebook address, after the shooting, it was noted at 0030 hours, that's 1230 hours for the people that aren't in the military, 12:30 a.m., that's almost going to be 1 a.m. in the morning. On 10/2, the account settings and privacy settings were changed. Okay, what you need to realize is that anytime you go on your Facebook account and change your things, it's recorded. Facebook keeps it, it's documented, and when the cops want it, they can get it. So if you change your privacy setting, if you delete a message, if you unfriend somebody and friend somebody, if you do anything on Facebook, it's recorded, it's documented, and the cops are going to get it. So they had at 12:30 after the shooting, hey, she just changed her privacy settings. Why? Because she was probably getting a lot of phone calls. She was probably embarrassed. She could have been, knowing that he was going to do this, if she would have changed her privacy setting before the shooting, that would be more of an indicator she was involved to me than changing it after the shooting. To me, it's reasonable after the shooting and the news media gets out and she's connected and her boyfriend's name's plastered in the news. Holy crap, I'm going to change my Facebook settings. To me, that's reasonable without necessarily tying her to having knowledge he was going to shoot people. Okay, at 2:46 on the same day, so this is 2.5 hours later, the Facebook account was deleted. Okay, so now we're getting, this raises my suspicion a little more. If I'm writing a search warrant and I'm saying, and I'm trying to connect her to this crime, I'm saying, okay, I can see her changing her privacy setting, but why did she wait 2 hours to delete her account? What happened, and when I interview her, that's going to be my questions, what happened between 12:30 in the morning and 2:46 in the morning that caused you to delete this? And I want her explanation. I want her to explain to me why she did that. I was getting a lot of phone calls. A lot of people were friending and asking me. Well, you know what? If you weren't on there monitoring it, you wouldn't know this. Why were you up at this time? And to me, it's reasonable. Look, her boyfriend, even if she just found out her boyfriend just killed a bunch of people, she didn't know he was going to do it. Holy shit. She got some money. She thought he was talking weird. She had no idea he was going to do this, and now all of a sudden it's hitting her. She just wants to disengage. I get it. I can believe that, but I still, remember, it's my job as a cop to be suspicious when there's nothing to be suspicious about. That's my job. I need to be suspicious so I can make sure, because not only am I trying to prove somebody's guilty, I'm trying to prove they're innocent and not connected. And I have to do a lot of questions and search and go through a lot of things in order to determine that. It's very easy for me to say, oh, okay, you look like a nice person, I'll believe you. Oh, I don't like you, I won't believe you. I like you and I will believe you. I need to have more than that as a cop. I need to get down and find some information. So you're a fiant, and your fiant is basically your officer. I usually put mine in first party. Most people write them in third party. I got tired of putting your fiant crap. I just put I. I started writing in the first person. I sent preservation request to Facebook. Now, when we send a preservation letter or a request to Facebook or someone else, basically what we're doing is we're putting that company on notice that, hey, a search warrant is coming. This is the focus of our investigation. This person accounts, the identified account is the focus of our investigation, and you need to preserve everything. I don't want anything deleted, put away, put into storage. You need to know that this account is subject to an investigation, and you're going to get a warrant. So start saving everything that happens in this account. So that's what a preservation letter or preservation request does. It's pretty easy. I had them typed up. All I'd do is write the name in, write their phone number in, and I'd fax it right to them. And that way I could say they were served with a preservation letter. Because then later when I go, hey, man, when I looked at this account at 1 o'clock, there's no information. It says her account was deleted at 3 o'clock and there's no further information. Why isn't there information? Then I can hold Facebook, because when Facebook comes in and gives me all this information, when this goes to court, the person that got the preservation letter is going to have to testify. Did you get the letter? Yes. And when you got the letter, what actions did you take? Well, we have a system in progress to where I go to the account and I click it has save all and monitor all interactions for friends or whatever, and the account, all interactions automatically saved into this special file, and then once we get the warrant, that file, that complete file, is turned over to the officer. Okay, great, thank you. And then if there's anything missing from that file, that person that comes and testifies for Facebook has to be designated as a certified record keeper or certified person that keeps records, bookkeeper, whatever you want to do it. She has to be able to say, yes, I am responsible for record keepings at Facebook, and I am certifying that these actions happened. So that's what this preservation letter triggers. And the quicker you get that letter out, the quicker the company will stop deleting shit, and it holds their feet to the fire to where they have to give you everything. If you send a preservation letter 2 weeks after an incident, the 2 weeks during the incident, before the incident, you may have lost information. So getting that preservation letter out is pretty critical if you don't have the warrant immediately. Okay. Further indicated motive of Nevada may indicate evidence of a crime and destruction of digital evidence. Okay, he's just saying that, hey, this is why we need the warrant to prevent this. You're affiant. That means the officer. Request a nighttime service of the search warrant due to the immediate need. Now, a nighttime service of a search warrant has to be put in a warrant because warrants can only be served from, depending on the state, it's 6 a.m. in the morning till 10 p.m. at night. And the reason they do that is because night warrants served at 3 a.m., it's very easy to mistaken the cop as a burglar. Cops get shot. People in houses get shot because they resist, because they're sleeping, and it's not normal business hours, so to speak. So search warrants are traditionally can be served anytime between either 6 a.m. to 10 p.m. I think in California it might be 7 a.m. until 11 p.m. or maybe 6 a.m. to 10 p.m. So it may vary state to state, but there's specific hours when search warrants can be delivered. If you want to deliver a search warrant at 3 a.m. in the morning, you must get nighttime service. And the reason the courts require that is because it's a higher danger to the people that you're searching and to the officers that search. And unless there's a really good reason to do this, we're not going to approve nighttime service. So a judge has to take nighttime service approval very specific. And so when he requests this, you have to say why you're requesting it. He's requesting it for said search warrant due to the immediate need to determine the extent and scope of the investigation. I'm not sure that's a great sentence. The possibility of co-conspirators. Okay, I agree with that maybe a little bit. Locate potential suspects. I definitely agree with that. And items of evidence which may be disposed of, such as firearms, ammunition. Furthermore, an outstanding person of interest exists. This is the key part to me. This is the most important. An outstanding person of interest exists, and the services warrant said to locate who may assist in possible locating or interviewing the related party, Mary Lou. So they're looking for Mary Lou, and they're saying she's still at large, and she may be involved, and we need to get in here now. We don't need to wait till 6 in the morning, because if we wait, I would have put, we need to get in this warrant because this is an ongoing crime. We have multiple murders. We have possible multiple suspects. We have indication that there's another suspect outstanding, and that person may be located at this residence, and there could be other co-conspirators that are either destroying evidence or fleeing, because this investigation has high media publicity, and it's on the news, and people are fleeing and possibly destroying evidence, and time is of the essence. We need to get in now. And that would have been, a quick version of why I want nighttime service. I also would have put in there, if we wait and we don't do this nighttime service, we risk the availability of evidence that we may seize of being destroyed. We also risk that suspects outstanding may further the conspiracy. Other people could be in danger, or they could escape. So that would be my nighttime service, kind of in a just off the cuff thinking of it. Your affiant requests a warrant be sealed. Now, remember, a warrant is a public document unless it's sealed. And normally we seal warrants because we have an ongoing investigation of parties and officers undercover, or things that if this warrant is disclosed to the public, it would hurt the investigation, and it would help people get away, or it would help people destroy evidence, or it would tell people that we're onto them, and now they would stop doing what they want to do. And because we have wiretaps in place and we're listening to these people and they don't know we're listening to them, if somebody sees in this warrant that we're getting information from the wiretap, then our wiretap will lose its evidentiary value and we won't be able to use it. Those are good reasons to seal a warrant. Here's why they're saying they want to seal the warrant. There are numerous victims where the next of kin have not been notified. Man, I don't know about that. That seems a little weak to seal a warrant. Whether or not this warrant is sealed, unless I have a bunch of victims listed in this warrant, how does that seal this warrant? To me, this is a very weak sentence in and of itself, if we're looking at this alone, to seal a warrant. The fact that there are victims out there that haven't been notified has nothing to do with me wanting to search the suspect's residence and his girlfriend's residence, and I'm looking for evidence of a crime. Absolutely nothing to do with victims have not notified a kin. To me, that should be, the judge should have went, unless you've got a list of all victims in this search warrant, now, if you list all the victims in this search warrant, then this sentence to me becomes relevant. For me, this isn't relevant because I didn't see any victims' names in here other than the victim, Paddock, who was doing the shooting, who in my book, I don't give a shit if his kin is notified because of this warrant. Everybody already knows who he is. It's already been in the media, and for me to say it's not in the media and we need to seal this warrant just to spare him, I think is BS. But that's just this sentence now. Let's get to this another sentence. Further, the current investigation is ongoing in order to determine motive and the possibility exists of outstanding co-conspirators in this mass casualty event. A seal is request to preserve the integrity of the investigation and the maintenance and specialized investigation. Okay, and this is still kind of weak to me. Most cops are going to be like, that's bullshit, dude. You don't want this getting out there because why? How does this hurt you? Again, a search warrant is only a public document once the return has been made. So this warrant is not public until after I execute it, I serve it, and then I do a return search warrant. And I'm going to get into return search warrant at the end here because they actually have a copy of it. That's when the warrant becomes public. So until I serve this warrant, nobody knows about it. It's still private. So to request a sealed warrant for the integrity investigation, I still think is a little bogus. If I wanted this warrant sealed, I guess I would probably say the reason I want it sealed, I don't know if I'd want it sealed. I don't really care about this warrant being sealed. The only time I would want a warrant sealed is when I was doing a return search warrant, because a return search warrant is after I served a warrant, I have to go back to the judge and say, Your Honor, you issued a warrant on this date. And then on this date, we served a search warrant, and here's what we found. We found the following items from the warrant you issued. Because if a judge gets a bunch of return search warrants that, hey, judge, you issued a warrant. This day we served it. We didn't find anything. Thanks a lot. Those kind of go against the credibility of the officer, the judge, etc. So judges don't like warrants being returned where they don't find information. So we have to notify the court on what we found, and was the warrant valid? Was it correct? And did we find what we were searching for? Therefore, it gives the judge confidence that he can believe us, and it gives the officer credibility that when I say I'm going to find something and I request a warrant, guess what? I find the stuff that I say is there because of my experience and training. So a return warrant is only done after we've done a search warrant. If at that point I want to file and have a warrant sealed, I should file the sealing then, not when I request the warrant. I think that's BS. But anyway, my opinion, you can hate on me. Some Las Vegas cop, you don't know what you're talking about. There's a complex. We need to keep it secret. Whatever. I think the sealing is BS. Okay. So, and now, speaking of return, this is a return search warrant. So, the return search and seizure warrant authorizes search and seizure of the following items in the address. So, when you do a return, It's connected to the original warrant. Now, when you do this return, now the warrant becomes a public document. Now is the time to seal it if you don't want it getting out. Now, I can see sealing this because we don't want people to know that we have information. If I found a passport of a co-conspirator and a plane ticket that he's going to catch a plane in 2 weeks, and I seized that and took photos of that, when I do the return, I want that sealed because I don't want the guy who's running, because I'm going to set up a surveillance in 2 weeks when he gets on a plane and catch him if we don't find him. So I don't want that information out. To me, that's a legitimate reason to seal a search warrant. This general crap about victims have been notified and preserve the integrity of the investigation, to me, is bullshit. Again, government overreach. Look, I was a cop. I wrote a lot of warrants. I know there's valid reasons to seal a warrant when you got drugs and you got guys outstanding and you got a large drug shipment and we're trying to track it and we know it's at this place and we're going to wait for them to sell it and we need to connect it. I get it. There's legitimate reasons to seal a warrant. I don't think there was a legitimate reason to seal this warrant. And the judge unsealed the warrant, which tells me at some point he went, there's really no reason to have this sealed. I would like to ask the judge, what exactly changed from the time you sealed it to the time you unsealed it? Because something had to change your mind. You signed to have it sealed, and now it's unsealed. Why did you unseal it? What changed? And his response would probably be, there was time between this. It wasn't emotional. That we know a lot more now. We're now convinced that there's only one person. We're now pretty much convinced there's not outstanding people. I don't think there's a need to have it sealed. That would be his answer, and I think that's reasonable. I'm just not sure, as a judge, if I was reviewing this, I would have said there's enough here to seal this. But that's me. Okay, so a copy of the inventory was left at the search. So when we do a search warrant and you do it, anything you take, you leave an inventory. Hey, here's what we took, and you leave it with a copy of the search warrant because it's required by law. So they left a copy of this at the warrant. So if they left a copy of this at the hotel in the room and you seal this, there's still a copy of this running around. But I digress. Again, I just don't think this warrant should have been sealed. So the following is the inventory of property taken pursuant to the warrant. And this is kind of blurry to read, but I'll try. Maybe I'll try to zoom in on it. I don't know if that's going to make it bigger or better, but here we go. Miscellaneous paperwork and photos. Yeah, that's kind of loosely. Why did you take those photos? Are they connected? I don't know if I like that. Miscellaneous, I think that says pills and bottles. Okay, I understand that pills and bottles will connect the person to the residence and will help identify the guy. And maybe the photos will help identify the guy. I don't know. Did he have photos of him and his girlfriend? Did he have photos of, Black Lives Matter? Did he have photos of Antifa? What were the photos? Did it say photos of him with Clinton donating money? What were the photos? Miscellaneous photos. That's not a very good detail. If I was a judge, I'd be asking a cop, what is this paperwork and photos? What were they? Okay, big deal. I gave you permission to go in and search for things connected to the case, and you turned back a return search warrant that says photos. Really? I don't know about this return here, guys. A Dell. Obviously, they took a Dell computer. Samsung cell phone. Okay, they got a serial number here. Digital drive. Okay, they took a drive. SD cards. Yeah, they probably need to take some SD cards. Now, somewhere when they take these SD cards, there's a detailed property sheet of things they seized. And on when you take evidence, if I put SD cards, I have to put SD card 1, serial number so-and-so. SD card 2, identified serial number so-and-so and has the name people I want to kill on it. SD card 3, me and Hillary Clinton. Anything that I have to identify these cards. This is a very short. Normally, when I did a return, I just gave them the damn evidence sheet because I didn't have to duplicate it. I just put evidence sheet of things taken incorporated within this report, and I didn't have to hand write all these little short things here. Just, you've already got the information. You've got a detailed list. Why don't you just give them the list? Rick, why are you picking on them? I'm not picking on them. I'm just saying why I do certain things and how I've done it and why I think it's a better way than, this handwriting crap that you can barely read. Arsenal shotgun. I can't. Arsenal SA something. Shotgun. Okay, so they took a shotgun. Looks like something, maybe a Stevens 12 shotgun serial number. Hell, I can't read that one. Another shotgun, another shotgun, another shotgun, another shotgun, another shotgun. So they took several shotguns from the party's house. 9mm, SIG. Man, don't be buying that crap handgun. Come on, dude. You got all that money and you're buying SIGs? All right, here comes the SIG haters. Why are you cranking on SIGs? You just like Glocks. Whatever. FN. Is that a S4? I don't know if that's supposed to be an M4, M6. I'm not sure. Smith & Wesson M&P 9mm. That might be a Glock. I don't know. That might be a Beretta 92F. Again, I can't read some of these. Not a good copy. Again, if I'd have gave the judge the copy of the actual warrant, who is this cop? Hey, dude. Officer right here. Dude, just give him a copy of your freaking evidence sheets you're going to turn into evidence. It's the same information, and you don't have to write it twice. It's a lot simpler. Rick, why are you picking on the cops? Shut up, you big dummies. Now, look, this is a 141-page document. I'm on page 14, and we're at already 50 minutes. So I'm kind of pausing and taking a drink. If you want to pause and finish watching, that's great. Basically, the gist of this, if you don't want to keep hanging around, is I'm going to get to all the evidence they seized, why they seized it, how they seized it, and give us more information, a clear picture. To me, after reading this complete warrant, I feel a lot better about what's going on in this investigation. And basically, they don't have nothing. They got the guy dead. They went in there. They shot him after he killed a bunch of people. The federal government dropped the ball. They let him buy all this stuff. They let him buy all these multiple guns. They knew he was buying it. He bought them when in the scope of the law. The laws didn't stop him, and all these people wanting more gun laws absolutely mean nothing because this guy did everything legally, and he still had all these guns. And the liberals will try to tell you that we could have prevented it, and it's for the children, and if we can only save one life and all this other bull crap, when in fact they had all the information in the world to stop this. They didn't. They failed. They got a counter-terrorism team for 6 years, and they didn't find crap. So that's my nuts and bolts to it, but I'm going to go through this complete search warrant like I said I would, and we'll go to this. So now we're at 971B. So 971A was probably the first warrant they did. I'm thinking B is more or less a piggy bank warrant they're doing after they did A, and they can either use A as an attachment to this to justify so you don't have to repeat and recreate the wheel. That's why your first warrant's so important. A lot of people can use your first warrant as a piggyback warrant to get other warrants, and they can just say, see search warrant A, and that gives them all the information. Then in my search warrant B, I can just put what I need very quickly and get a second piggyback warrant. And again, order sealing affidavit, search warrant 17B. So this order has been blah, blah, blah on 2 October. Again, I'm not a fan of this sealing. Attaches search warrant ordered sealed pending further. The court accept copies provided by the county clerk, etc. So the judge signed the sealing document, and we got into search warrant. This is B. Pretty much the same as the other one. This is maybe a different officer, made before him, William Breyer, affidavit attached here too, incorporated. Firearms. We're looking for firearms. We're looking for a person located at the president's. We're looking for all vehicles of the president. We're looking for articles of personal property that would establish indicia, ownership, care, custody, and control, not limited to keys. Sometimes you want a key to the house, key to the building. If you find somebody in the house, they go, I don't live here. Then you take their keys and you go, you got a key to the house and you don't live here? You know what? I'm taking his key because you got a key to this house. Rick, you can't do that. That's unconstitutional. Shut up, you big dummies. Okay, canceled mail envelopes, rental agreements, etc., utility bills. This guy got a little bit more detailed. Objects which bear the person's name and phone number and address. So any object that does that, pretty much, again, it just establishes care, custody, and control of the residence. That way, when you find things in the res, you connect it to the person because the person is already connected to the residence. So you're connecting all the dots. Commercial and improvised explosives, chemical components, toxic chemicals, ignition devices, etc. All right, so, and now said premises are described. So this is the Mesquite House. So they're basically the same warrant, and they're trying to get in the Mesquite House. There are no cars at the residence outside the garage. I am satisfied there are probable cause, blah, blah, blah. Again, now this guy, search warrant, here you go. So let's see if he gets down. Application, affidavit, search warrant. So let's see if his hero sheet is better than the other cop's hero sheet. William, badge number, police department, whatever, 6'3", being first duly sworn. Ooh, I wonder who's second duly sworn. I wonder if there's a third duly sworn. Okay, deposes and says that it is the affiant herein and is a detective with the Las Vegas Police Department permanently assigned to the counterterrorism section. Wow. He has been employed with the police department for 17 years and has been assigned to the counterterrorism 6 years. That's it. That's the hero sheet. Man, you guys got to really work on your hero sheet. What the hell have you been doing for 17 years while you've been on the police department? And what the hell have you done in the 6 years that you've been on the counterterrorism team? Big deal. You've occupied a seat. You collect a government check. You've taken sick leave and vacation. And you've filed a couple grievances. What the hell else have you done that makes a judge believe that you are actually establishing probable cause to search? Man, these are weak hero sheets. I'm sorry, Las Vegas PD. If you get any heat, you can come here and cry. Well, by Nevada law, that's all we're required to do, and you don't know what you're talking about. All right, whatever. I don't know, but I'm sitting here doing a video, and you know what? Either people can watch or they don't have to watch. I don't care. So don't come here and cry. I don't need your pink panty Nevada badges here crying. He's picking on Las Vegas. Shut up, you crybabies. All right. Said premise to be described, the residence, tan roof, blah, blah. Okay, very specific detail. And again, we'll repeat what we're looking for, guns, digital evidence. And we move down, digital drive, blah, blah. Let's get down to the property described constitute, which tends to demonstrate that the criminal offense of murder, weapons of mass destruction, NRS 200-2, there are multiple counts, act of terrorism, battery with use of a deadly weapon, assault with a deadly weapon. So he gets a little bit more specific on his charges than the other officers, has been committed. Okay, so most search warrants require a felony committed. Now, you can get warrants for misdemeanors. A lot of people don't know you can. In California, it says for any public offense, you can get a search warrant. It used to be you could only get a warrant for a felony. And then the courts over time have allowed to get any public offense. Okay, let's see. In support, constitute probable cause. The following facts are offered. On Mandalay, blah, 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 received. At the time, the fan unassigned confirmed approximately 406 victims were transported to the local hospital suffering from gunshot wounds. 406 victims were transported suffering from gunshot wounds and injuries related to the mass attack. So we don't have 406 people with gunshot wounds. We have 406 people. Some had gunshot wounds. Some had injuries related, such as broken ankles, skin knees. See, they still don't get in here on how many people were actually shot, how many people were hit with a bullet, how many people were actually hit with maybe a ricochet or a partial bullet, and how many people were hurt because they got tripped, stampled, or because the cops didn't help or there wasn't a good evacuation, etc. They're not telling us still how many people were, and they know this. They just don't want to say it because they want to say he fired 1,000 rounds and want us to think he hit everybody he shot at. And instead, I'm going to venture to say there were less than probably 50 people with actual gunshot wounds. Not making light of the 50 people. Additionally, 51 victims have been deceased as a result. Again, he didn't say 51 victims were shot and killed by the suspect. 51 victims have been confirmed deceased as a result. That means could have been heart attacks, could have been hit by cars, could have been died. If somebody dies, they trip and fell and hurt the ankle, and then 6 weeks later they died because they bled out or because they caught pneumonia because of their injury, that counts as a death for this victim. So out of these 51 victims, how many people were shot by the suspect that we're saying is the biggest mass shooting ever? They don't want to tell us that, and it kind of irritates me, but you know what? That's just government being government. Citizens and officers in the area were able to determine that shots were being fired 32nd floor of the Manatee Hotel with the address hotel. Officers were able to identify the shots were being fired from rooms 32-134 and 32-135 down onto the ground levels of the concert goers, which numbered approximately 30,000 people. Okay, so they're saying there was 30,000 people there and he was shooting at them. Tactical entry was made into the room in order to preserve life under exigent circumstances. When they got that little statement dialed down, I'm just going to copy that and keep repeating it, and it'll sound like it's reasonable. And they located a deceased male, apparently self-inflicted gunshot wound. Why is it apparently? Well, okay, maybe they didn't. At that point in time when they wrote this, it was still new. I'm pretty sure now they know if it was self-inflicted because they're going to have, what is it, stippling or gunshot unburnt residue. If you shoot yourself in the head with a gun close range, you have unburnt powder that embeds in the skin, so you could tell the gun was pretty close. Doesn't absolutely mean it's self-inflicted, but it means the gun was close. Anyway, the male was identified by the way of a driver's license, Stephen Paddock. Inside the room, law enforcement further observed multiple firearms in close proximity of the body of Paddock. In total, approximately 22 rifles and 1 handgun was located in the rooms. Okay, so now we know, again, an officer swore to this, that this is true and correct. I don't know if the media ever reported this, but now I believe that they found 22 rifles and 1 handgun. That's what I think they found in the room, because this officer just swore to it under oath, under penalty of perjury. All right, preliminary investigation. Paddock was subject of involved firing described to the concert goers, etc. All right, so let's go down further. A check of the room registration, review the room with it. We already had that in the other one. Records indicated further that Daly was registered in the same rooms. Let's see, an emergency administrative subpoena for the Water District. Okay, so he's pretty much repeating everything here. Facebook account stubborn, 246. Facebook account deleted. Investigative personnel sent preservation letter, evidence, okay. A search warrant was issued and being authorized, blah, blah. So now they're saying we already had a search warrant issued for here. So he's establishing that the other warrant. Basically, he's just repeating all this. I would have just put the attached warrant is enclosed and incorporated, but whatever. The affidavit in reference to a piggyback warrant of the same location based on additional information now known to your assignment. So now we got to say, okay, I want a piggyback warrant based on new information. What's the new information? In part. I don't know why we're like in part. Give me the new information. The judge needs to know it. In part, the additional information being as follows. A Chrysler Pacifica vehicle bearing Nevada license plate registered to Stephen Paddock was located on the second floor of the Mandalay Bay valet parking. Inside the vehicle, FBI agents located 100 pounds of ammonium nitrate powder, basically tannerite, whatever explosives. You mix them and they shoot it. So tannerite is not listed as an explosive by the ATF, but they're saying it is an explosive here, which I'm not sure. If I was a judge, I'd have a problem with that. Which is an explosive substance, commonly referred to as tannerite. The federal government does not list it explosives because you can buy it at I can go to any sporting goods store here that sells guns and ammo, and I can buy tannerite. It's not an explosive. Now, maybe explosive material when it's mixed, but they can ship it on the ground, and until it's mixed, it's not an explosive. So it's unclear to me whether this was mixed, and that's why he's saying explosive. He didn't really clear that up. And to me, when I'm explaining something to a judge in a warrant, I want to educate him. Not only do I want to educate him, I want to educate the defense attorney and the jury when they read it later in court. So I want to make my warrant clear. I don't want to have problems. To me, a defense attorney is going to be, well, when you said you found 100 pounds of ammonium nitrate, it really wasn't explosive, is it? Because the ATF identifies an explosive as tannerite is not an explosive until it's mixed. And this wasn't mixed. So when you said it wasn't explosive to the judge, isn't it true you were just trying to elevate yourself and to make this seem more serious in order to get a warrant to search my client's vehicle? Isn't that true, officer? No. Well, why did you say explosive when, according to the ATF, it isn't explosive? Well, I didn't know that, or I wasn't clear. So you wrote a warrant that you wasn't clear, that you swore to, and you had a judge sign a warrant that you wasn't clear and you didn't know, and you got this warrant based on information that you didn't know because you didn't take the time to find out exactly what you were putting in your own warrant that you wrote and swore to. Is that right, officer? And there goes the officer's credibility down the tube, and the jury is kind of like, Jesus Christ, these guys are a bunch of Mickey Mouse not knowing what the hell they're doing. This guy's been on the department for 19 years and worked for the police department. What the hell has he been doing? He don't even know what an explosive is? That's how shit falls apart in court. So, again, I'm not doing this to crack on the cops. I'm doing this to educate cops on how things go bad, and when you write something in a warrant, warrants that are longer are better than warrants that are short. I know cops that would do warrants in one paragraph. They were lazy. They would take it to a judge that they knew. The DA wanted the warrant because he wanted to make his case better, so he would sign it, and the judge would sign it. And they were the most BS bullshit warrants I've ever seen in my life. And they were one paragraph, and I think they should have been thrown out, and any defense attorney worth his salt would have got that thrown out, and they never challenged them because it was just a good old boy, and you know what? They got a warrant. We'll just go away. You need to write your warrant as if, hey, this is a college course on warrants 101, and I'm educating the judge, the prosecutor, the defense attorney, and the jury. Anybody that reads my warrant, it should be, keep it simple, stupid. Everybody should know what I'm talking about and what definitions I'm using, and it needs to be very clear on what I'm saying. Cops get in a jam when they do warrants fast. I realized this was an ongoing incident. There was a lot of dead bodies. There was a lot of pressure. People were writing these warrants in the middle of the night, just being woke up, and there was a lot they didn't know. I get it. I'm not saying these officers are a piece of shit. I'm saying from a learning standpoint and from a criminal defense attorney or a prosecutor, if you're reviewing a warrant and you got questions, it's your duty as the DA to tell that cop, you know what? I want this clarified because it really wasn't explosive. I want to know if this was mixed and the two powders were mixed or they weren't mixed. And if it was mixed, how did you know it was mixed? And how did you see it? And do you just see components? And did you see the name tannerite? Because is this tannerite or is it commonly referred to tannerite? And what is tannerite commonly referred to? Because they don't describe. Okay, here they go. The substance is a shock sensitive to bullets and will explode on impact. That's what tannerite is. Due to this explosive substance being located in a vehicle at the same crime scene, there is a high probability, based on my training and experience. What training experience? Because you were a cop for 19 years? You didn't put any training experience. If you had put in your training experience in your hero sheet, I've investigated several crimes involving explosives. I've written search warrant on explosives. I've found tannerite and explosives in other documents. Then I would agree, based on your training experience, you know. But just to say, based on my training experience, you don't have any training experience other than being a cop for 17 years and being on the task force for 6. That's why your hero sheet is important. If you're going to say based on my training experience, then your damn training and experience needs to justify what the hell you're jumping to a conclusion. Because this is a conclusion. When we say based on my training, we're making a conclusion. And what are we basing our conclusion on? It's supposed to be on formal training, informal training, on-the-job training, investigative, talking, going to conferences, going to, training conferences with officers, going to investigating, assisting other agencies in explosives. I need to say why, based on my training and experience, that I jumped to this conclusion. This warrant is weak on its face. Does it matter? No, because the guy's dead. If somebody was facing life in prison, I would be tearing this warrant apart. Kind of what I'm doing here in a short version. Believe me, if you have a bunch of attorneys doing this and they're getting paid to do this for hours and weeks, they're going to tear it up a lot more than I am just off the cuff by reading, jumping through the lines in here. All right, so let's move on. Your client requests nighttime service due to the immediate need to determine the extent and scope of this investigation. What? Due to the immediate need? All right. The possibility of co-conspirators, to locate potential suspects, items of interest. Furthermore, this is a piggyback warrant on a search warrant that began early morning at 700 hours with the concern that Mary Lou may be located at the residence. While that concern has been dispelled, so basically, I'm glad he said that. He did good here by saying we're no longer looking for her. She's not our primary focus. Then he goes into there is still a need for a nighttime search warrant, has service of the prior search warrant has begun, and the search is likely to last throughout the day and evening. I'm not sure if Nevada has different laws. As long as we start a search warrant in the allotted time, we don't need nighttime service. The only time we get nighttime service if we're going to serve it after that time. So if 10 o'clock is a cutoff and we're getting a warrant at 9 p.m., then we can say, I want nighttime service because we may not be able to get to the residence until 10:30, which is 30 minutes past the cutoff. Therefore, nighttime service is needed. So then I would justify it. But if I'm starting my warrant at 9 p.m. and we're searching till 3 in the morning, I don't need nighttime service to keep searching at 3 in the morning. Once my search begins, that resident belongs to me until I leave. Now, once I leave and abandon or secure the place, in order to go back in, I need to get an additional warrant. That's why when you leave a search warrant, you need to make sure you're done. I can't tell you the number of times we've left a search warrant, locked the door, got down the street, got back to the office, we're booking in evidence, go, hey, who grabbed that thing that we found? Nobody grabbed it. It's still in the residence. We're like, shit. We got to go back. We got to get another warrant to re-enter the house to go seize that evidence. Now, I'm not saying this was ever done, and I'm not saying I ever cooperated in anything like this, but I have heard that some officers will go back, just break into the residence, grab it, and take it out and never say it was left. Is that wrong? I think it's wrong. Is it planting evidence wrong? Look, it's wrong. I don't want to be involved in that. I didn't do that. But it's easier than going back and getting a second warrant. Just go back in to grab something that you left on the table that you should have grabbed in the search warrant. But to me, writing a second warrant, it may take me an hour or two. What the hell? I'm getting paid, probably getting paid overtime. I don't care. It's my job. I'll do a second damn warrant, and it's pretty quick. Hey, Judge, I need to go back in this warrant because attached is the warrant that you originally issued. When we were in there, we left this item on there, and we got to go back in and get it. Does it make it look stupid? Maybe. Does it make it look like we're incompetent? Maybe. Is it the right thing to do? Yes. You can never go wrong when you just do the right thing. Remember, the right thing is never the easy thing. The right thing always takes more time. Usually you might have to eat a little crow. It's a little bit harder to do, but it's just easier in the long run. If you take the time it takes, it normally takes less time. The guys that would go back in and grab something that they forgot without getting a second warrant, if it ever came out, their credibility would be ruined, their warrant would be ruined, the guy may go free. The fallout would be horrible, and it's just not worth it. Do the right thing, and you know what? If you look bad, you look bad. Anybody thinks that I ever didn't look bad, well, you're crazy. I stepped on my pee-pee many a times out there in the field doing things, and that's how you learn, you get better. Remember, good judgment comes from consequences of bad judgment. All right, I digress. Let me drink coffee here. I'm just getting hoarse. All right, here we go. Search warrant began and may last throughout delay and not even. Oh, your final request, the warrant be sealed. New to numerous victims. That's a bullshit sentence. New to numerous victims and kin have not been notified. Who cares? How does that affect the warrant? How is that going to change your ability to conduct this investigation? How is that? That has nothing. If I was a judge, I'd be like, what does that have? To me, this tells me the judge either wasn't reading it, didn't care, or isn't specific. I guarantee you, I talk about Judge Ramsey, or Ramey, I think it's Judge Ramsey. He was a black judge in the Sacramento courts. And I used to love taking my warrant stamp because he didn't play no BS, and he made me a great warrant writer because he would not let anything slide. He would ask me questions, and he would not let a weak warrant go through. The cops I'm talking about doing those one-paragraph, cheap-ass warrants, they would never take a warrant to Judge Ramsey because he would be like, get the hell out of here with this piece of shit. I love that judge because he didn't play. He was straight up. He did his job. He did it the right way. He didn't cut cops slack because they were cops, but he was fair, and he did good freaking warrants, and he made me better every time I took a warrant to him because I didn't even like him asking. Because at the end, the more warrants I took to him, it was like he would look at me, I would look at him, he would go through it, and he would kind of look at me up through his eye, and because I'm waiting for a question, and I didn't like questions. I didn't like when a judge had to ask me a question on my warrant. To me, I failed if a judge had to ask me questions. That means I didn't make something clear in that warrant. My judge should be able to read that warrant, have a clear picture of what's happening, what I'm doing, and be able to go, no problem. Here's your warrant. Go out and search and destroy. That's what I wanted from a judge. So Judge Ramsey, man, let me tell you, I like that guy. He was my favorite judge to take a warrant to because he would not let this fly. You brought that in Judge Ramsey, he'd look at you and be like, okay, officer, and he'd say it in a stern voice, officer, please explain to me how the next of kin being notified justifies this warrant being served or being sealed. And that officer's feet would be held to the fire. And the officers start tap dancing. They'd be like, well, Your Honor, I only copied that because the last guy that wrote the warrant, he put it in his warrant, and you didn't sign the first warrant, but I just copied it from his warrant. Well, you know what? It shouldn't be in here. Take it out. And he would make you go take it out. Good. I like it. Anyway, further, the current investigation is ongoing in order to determine the motive and possibility exists of outstanding co-conspirators. Okay, I'm okay with that statement. That in and of itself to me is enough to get the warrant sealed. A seal request for the order, integrity of the investigation, specialized investigative techniques. That's what I call a clad cookie cutter seal. I guarantee you, if you read every warrant that's written in Las Vegas and they seal a warrant, you're going to see this statement and probably this next of kin. You may see this one because there's only so many reasons to seal a warrant. Once you have a good reason, if it's there, then use it. There's no reason to recreate the wheel. All right, let's see here. Let's move down a little bit further. So now we're on search warrant 17971 C and D. That means this is probably the third and fourth warrant they've done on this case. And what are we looking for here? The state of Nevada, any peace officer, proof made, sworn before, blah, 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 oral paperwork such as rent receipts. Duplicate of original search warrant. Okay, so this looks like a duplicate of the original search warrant. Mandalay Bay. I'm satisfied. Where are we going down here? We're still on C&D. Application for telephonic search warrant. So now we're going for information on telephones. Or no, this was the telephonic warrant. So a telephone warrant, basically a phone warrant, is where you call in the judge and you get a warrant over the phone. It's quicker and it's easier. And if you're on the scene and it's rapidly evolving and you're on scene, instead of leaving and securing and lives are at risk and you want to do it quick, you can just do what's called a phone warrant. Basically, you call the judge swears you in over the phone, and you explain your probable cause as you're going to write it out. You read it to him. He says, okay, I believe, and he says, I authorize a warrant. And then you get permission for him to sign his name. You sign his name, and you say, Judge, I'm signing your name. He says, yes, sign my name to the warrant. Now the warrant is signed by a judge with his authority, and a judge can give an oral order. It doesn't even have to be written. Most cops can kind of like it when it's written and signed because it makes it more legitimate. There's less reason for confusion. But technically, I can call a judge up, explain my probable cause, and say, I want to go search, and the judge can tell me on the phone, go search, and I can go search. I have an oral order. Now, there may be some state statutes that require all search warrants to be written and signed. I've never heard of it. If there is, maybe there is in Nevada. But an oral warrant are authorized within the law. So this officer is getting a telephone warrant, and we're going to go through this telephone warrant. So the following transcript has been transcribed, recorded, detective. Okay, JM, judge, and JM I'm assuming is, let's see, recorded. Who's JM? JM, Jerry McDonald. So JM is Jerry McDonald. Okay, Jerry McDonald. So Jerry says, Judge, they got because it was transcribed. Do you understand that this phone call is being recorded? Judge, yes. N.A. is Judge Nancy Alf. Okay, the officer, Judge, this is Sergeant McDonald, blah, blah, blah. I'm making an application for a telephonic search warrant pursuant to NRA, blah, blah, blah. I am talking to Judge Nancy at this time and date. The judge, please raise your right hand. The officer. Go ahead, ma'am. The judge. Promise the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Oh my God, they said the evil word. I can't believe they said that. How can that be? Allah's going to be upset. If this will be a racial incident if there's a Muslim involved. Rick White, shut up, you big dummies. The crazy hypocrisy of our government. All right. So, yes, I do. Thank you. Judge, has previously stated my name is Sergeant Police Department. I've been employed for the last 24 years. I'm currently assigned to the task force. There's that cheap, easy hero sheet. The judge. Officer, and this is where the judge could have very easily, it's being recorded. Officer, in the 24 years at the police department, how many search warrants have you written? None. Officer, in the 24 years of the police department, how many search warrants have you assisted in? 27. Okay. And at your time on the task force, officer, have you ever written a search warrant? No. Have you ever assisted in a search warrant? Yes. In those search warrants, did you find evidence you were looking for? Yes. Did you help in establishing a probable cause for any of those search warrants? Yes. All those things are relevant to his training experience. This bullshit hero sheet of I'm a cop for 24 years and I'm on the team is just cheap to me. I know I said it before, but I'm going to reiterate it because I think it's important. And maybe it's not important. Maybe the judge will say it's not important and the court will say it's not important. If I was a defense attorney, I guarantee you it'd be important. Okay, as a judge on October, I was called out. Mandalay Hotel Casino. County Narava arrived at the location at 22:10. That's 10:16 hours, 10 p.m. for those. Assume responsibility of the investigating a possible officer-involved shooting and an officer shooter. Ooh, wait a minute. Wait a minute. Why was there an officer-involved shooting? Who shot at the officer? Did they shoot him or did he kill himself? Now, he may have just, again, this isn't clear. Why isn't it clear, Rick? Well, because I'm an idiot. And if you write a warrant like you're explaining it to a 5-year-old, then you don't have to worry about somebody going, I'm confused. I'm confused. Who was involved in the officer-involved shooting? Are you talking about officers on the streets that were shooting up at the window? Are you talking about officers that were shooting in the doorway when they tried to make entry? Are you talking about the officers that shot the suspect when they went in that they're now saying shot himself? What do you mean you were investigating a officer-involved shooting? Possible officer-involved shooting and an active shooter. Again, it's not clear to me. I digress. Let me move on. Force investigation team detectives and crime scene analysis were requested to respond to the investigation, collect evidence, and document the crime scene. And there's probable cause for me to believe a certain property described, okay. The Mandalay Hotel, the Chrysler Pacifica. Let's see here. What else? The property referred to is sought to be seized and consists of the following. So here's what we want to be seizing. We're looking for paperwork, rent, etc., basically indicia that establish care, custody, and control of the premise or the building or the home. Written correspondence documenting the active shooter plans. We're looking for plans of conspirators or co-conspirators that will attach and tell us why or develop motive on why he did this. Photographs and video, audio tapes, cellular phones, electronic, telephone information, history, ID history, answering machine messages, voicemails, phone, directories, contacts. We're going to get all that from the phone. Microscopic examination, document of evidence, discovered of evidence, trace, fingerprints, blood, hair, fibers, fluid. Basically, they want to seize everything that's connected to the crime. Clothing, not limited to pants, socks, undergarments, etc. Unknown physical items relating to the death. What else are we looking for? We're looking for backpacks, purses, cellular phones, possession belonging to Stephen Paddock. Firearms, to include handguns, shotgun rifles, spent casings, etc. The body, so they're seizing the body, and they also want to search that body. In support of the constitutes probable cause following. Okay, let's see what we got here for probable cause. Approximately 10:20 dispatch initiated active shooter. The event was attended by several thousand people. The massive law enforcement response included tactical teams from Las Vegas SWAT, firing weapons into the elevated position. Information was learned that a potential suspect was firing a weapon from an elevated position on the 32nd floor. Here's where we get into details that the media may not know. And in a search warrant, they're going to put that in there to the cop. Goddamn freaking automatic bullshit. If I press more than twice, it freaking goes automatic. Okay. Uninformed officer event. SWAT officers arrived at 32nd floor, pinpointed the shooter's location in room 32-135 as SWAT officers breached room 135 breach, meaning they forced entry. They observed Stephen Paddock place a gun to his head and fire one round. Wow. Nobody has told us that the cops watched him kill himself. Why wasn't that information out here? Why is it that we've just been getting, we suspect he killed himself? Right here in a sworn affidavit to a judge in a search warrant, SWAT officers breached and they observed Stephen Paddock place a gun to his head and fire one round. Why didn't we know that? To me, this is huge. Why isn't the media reporting that we know he's committed suicide because the officers watched him shoot himself? I've never heard that until right now, and I read this warrant already. I was scanning through it, and I missed that. So the officers actually watched him kill himself. They also observed numerous weapons, including but not limited to handguns, rifles, electronic storage devices in the room. Somebody's lying, because in the other warrant, they said they suspected he killed himself. And this guy is saying the officers watched him kill himself. So it's not suspected if they watched him. Again, if I was a defense attorney tearing apart these warrants, I would ask which officer is lying. The officer that wrote the warrant and said he suspected he killed himself, or this officer that said they saw him, because somebody's lying. Well, Rick, he just didn't word it correctly. One of them's lying under penalty of perjury and provided false or inaccurate information in the trying to get a search warrant. Man. All right, not limited to handguns. Through my training and experience, I have learned that an examination of the crime scene and recovering the above property is necessary to provide circumstances involving the officer shooting up. Okay, that's good. He kind of dictates why his experience and training helps him. A thorough forensic examination of all rooms and vehicles necessary in order to establish the location of the crime, its extent, circumstances surrounding the crime. The search may involve damaging and removal of such items, such crime. Now, you need to get this in there, because when you start cutting out carpet, and if there's blood spatters on a wall and you cut out a piece of the sheetrock and you want to take that with you, you take pictures, you start destroying items, you pull up wood floors. When you do that to property, you want to have a judge's order. You just don't want to be seizing things. Now, can you do it if he didn't put this? Could he take carpet? He could, but this makes it clean, and that's what I'm talking about in your warrant, to be specific. You want to make it clean. You don't want somebody to come back and go, you didn't get the judge's permission to cut out that carpeting. You didn't get your judge's permission to take that door that had his fingerprints on it, or that had his face print on it with his face and blood and DNA evidence sliding down from where you threw him against the wall. You want to make it clear and easy. All right, I'm at an hour and 26 minutes. Holy shit. Your affiant requests a collection of backpack. Okay, we already went through that. Application telephone search warrant contains physical evidence, relationship to motive, potentially disclosed, but okay, body fluids, fibers, chemicals. Your affiant requests a collection of cellular phones. Also refer to electronic storage devices. To include but not limited to tablets, surveillance equipment, computer. Stephen Paddock, which is examined, show recent communications, including text, phone calls, audio and video recordings to close at the relationship. Okay, so we're getting all the electronic evidence. This type of data search specifically includes emails, documents. So he's covering the bases. So basically, he can search for anything and everything, and that's good. You want to get that all in there. Again, you're preventing a defense attorney from coming back saying, "Officer, when you picked up the phone and you looked at his call log and saw that he called co-conspirator so-and-so, and then you got that phone number, did you have permission to go through his call log?" Well, I had permission to search the room, and the phone was in the room, so therefore I had permission to search it. But did you have specific can it put mud in the water? Yeah. Is it absolutely necessary? I don't think so. I think the judge is going to go, you know what? I gave him permission to search the room and the phone, and you know what? I think it's reasonable to include the call log, text message, etc. Does it have to be in a warrant? Maybe not. Is it a little extra to put it in there? Yeah. But does it make it cleaner? Absolutely. Electronic store devices capable of storing operating systems, metadata, RAM, etc. Okay, basically we want to be able to take everything that we want to take. Within that RAM, parties, again, you can cookie cut all these out and place that in a warrant and make it. And I have a master warrant on my website to where I kind of did that, to where I just have to cut and paste. When I'm doing a warrant, I want digital device, I simply copy and paste it and move it over. Parties engaged in illegal activity, hide and restrict information digitally stored. They may also utilize hardware devices and access. So, okay, bypass any password, encryption, etc. So now he's making sure they don't have to go get another warrant to get the password. Electronics, unknown amount of data. Additional data may be hidden in files, program files, deleted files. So he's just basically getting... I kind of think what he's covering here is to get a forensic examination of the hard drive. A lot of times when cops seize a computer on a search warrant, they seize it, and then when we take it, and I used to work in a community crime task force where I would get these, and I would ask the guy, hey, man, if you want me to do a forensic analysis on this drive, you got to give me a search warrant saying it was there. And they're like, oh, I don't have that. So then what I would have to do is go get another warrant, attach his warrant to seize the computer. I would have to do a piggyback warrant in order to do a forensic examination on the hard drive in order to look at that hard drive, hook it up to my software, and figure out what was on there, what items were deleted, what was his search history, what did he delete and erase, etc. In order to bring all that back up, I would need another warrant. But if you put that in your original warrant like a good officer, then you help your forensic guys. They don't need a second warrant. Because when I get a search warrant, I can have any officer of any specialty. The only thing I might add to this warrant is, Your Honor, there's other officers that will be doing part of this search either at the house or at the garage for forensic evidence or at the morgue or at the forensic examiner computers, and I want authorization that these officers have permission to carry out any searches on my behalf. Now, I'm the officer that got the warrant. The officer gives me permission to allow these other people to do my search for me because they have special training in special areas. Therefore, I don't have to get another warrant for them to do that. Because this is in here, me as a forensic examiner, if he brought me this hard drive, I'd be like, all right, your warrant covers me. I can go ahead and search it. If this wasn't in here, I'd be like, you know what? Before I start digging in here and find something that's critical, I need to go get a second warrant. I'm going to do a piggyback warrant on your warrant and get a second warrant saying I'm authorized to search this forensically. So, again, this was a good on their part. They're covering their bases. This guy obviously has a little experience in warrants if he's putting that in there. A search would also include collection of unknown physical items that may be discovered during the search, but not limited to clothing, footwear. This basically, I want to seize everything that I think is important or connected to the crime, and I want to cover as many things as I can. The evidence, domination, and control necessary to establish control, aforementioned rooms, also identifying the perpetrators, such as evidence normally maintained upon it, normal room, vehicles. Let's see here. Laptop computers throughout my training experience. Did I go 2 down? Okay. Commonly have cell phones, electronic devices, game consoles, tablets, and items carried on their persons or in their vehicles or residence. Information stored on these types of devices, such as text messages or disclosed. So he's basically saying, look, I know that everybody has cell phone, computers, etc., and when I search over my years of experience, that I find these things, and I also know that we always find evidence that will probably lead us to motive or other co-conspirators or how this crime progressed, etc. So, good statement here. I got no problem with that one. Let's see here. Information in diaries, letters, writtens, videotapes. He's getting pretty detailed. This is probably all cookie cutter. He's just cut and pasting it. He didn't actually write this out. Somebody had to write it out on the first one, which is why I think all departments ought to have a search warrant database or ought to have a database where officers can go in and cut. And the DA has already approved it. And if you get a warrant past the DA, if I'm searching for drugs, there should be a cookie cutter paragraph that I can cut and put in my warrant. And if I'm searching for digital evidence, there should be a cookie cutter template that I can cut and put in my warrant. That way you don't have to recreate the wheel, and you always know you're getting good information, and the courts are familiar with it, the DA's familiar with it, and it's there, and it covers your bases. If you do it by memory, now if you do it enough, you can do it by memory, but if you do it by memory, there's always a chance you'll forget one of them. I'll put cellular phones, personal desktops, I'll leave out laptop, and then I'll go in there and I'll seize a laptop. And then later the defense attorney is going to argue that you didn't put laptop in there, but you seized it. You put desktop, so which tells me you were looking for a desktop. You weren't looking for a laptop, were you, officer? Yeah, I was. I was looking for any digital evidence. So it just makes it easier and gives the defense a less chance to challenge your warrant. That's what more information does. It helps you. All right, your final request search warrant be sealed. Here we go. This is an ongoing criminal investigation. Revelation of the facts supporting this declaration may damage the continuing integrity of the case due to the potential outstanding suspects. They were saying right from the start that we don't think there's outstanding suspects. Yet every warrant they're saying there is. Now, I, as a defense attorney, would be saying, what date was this written? And if this was written after a date that the sheriff did a public press release saying we do not believe that there's any outstanding suspects and we believe that he acted alone. And now we have an officer swearing in a warrant that we believe there's outstanding suspects. Somebody's lying. And as a defense attorney, that's what I'm looking for. I'm looking at inconsistencies. I'm looking at bullshit reasons to seal a search warrant that the officer knew was bullshit or knew wasn't true. And if he didn't know it was true and he thought it was true, then I'm going to find evidence that makes it look like he should have known. And that's going to question his credibility. That's why search warrants are important. All right. After reading the identify Stephen Padgett, potential induce person involved, should the facts be known that the affidavit become known, the ongoing investigation and safety of the community could be in jeopardy. Again, this is cookie cutter crap. I don't believe that this warrant getting out would jeopardize. If it would, I want specifics, and as a judge, I would want specifics. And there's a critical thing here that people all forget. When a judge asks a cop a question, a search warrant is a written document, and it falls within the borders of that document. And anything outside the borders cannot be used in this warrant. So a judge, when a defense attorney says, Your Honor, he said that he wanted this warrant sealed for this reason because of outstanding suspects, he can't later say, well, the judge asked me, do I think there's outstanding suspects? And I told him, well, you know what? There was a text that I saw, and it went to a party that we haven't identified yet, so I'm not sure if he's involved, but he could be an outstanding suspect. And the judge went, oh, okay, that makes sense, and he signs a warrant. That's incorrect procedure. If a judge asks a cop a question when he's doing a warrant, it is the responsibility of the officer requesting a warrant to add that question and the response in the warrant. The judge cannot say later, because the judge has a lot of cases, he has a lot of warrants. He cannot be expected to remember, if he asks a question, what question he asked and what the answer was. And that's a critical part that cops think, oh, I can go in there and start bullshitting the judge. I don't need to put in a warrant. I'll just sit down with the judge and bullshit with him, and I'll answer all his questions, and he'll sign my warrant. It's bad on the judge, and it's bad on the cop, because the defense attorney is going to make you both look like idiots, because the judge knows that he's issuing the warrant on what's written in front of him. And the judge can't come back and say later, yeah, I issued the warrants on what's in front of me, but I believe me and the officer talked about a few things that aren't in the warrant, and so that also helped me. You know what? That's not fair, because the defense doesn't get that in discovery. The defense doesn't know what questions was asked, and he doesn't know what answers were asked. And it's on the responsibility of the defense or the prosecution to give the defense everything they knew. And if you've got information on the side that you and the judge are knuckle bumping in the back room, and I've seen it done, and cops don't put it in there, it makes the warrant invalid on its face. And that's how search warrants gets overturned. If you bring a warrant in and a judge asks you a question, you better be ready to modify that warrant and write it. And I've even asked the question, I've just written the question out. At the bottom of the warrant, I've written, judge asked about blah, blah, blah. I answered with blah, 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 blah. And I add it to the warrant, I initial it, and me and the judge sign it. And, instead of going back and doing a whole warrant, a couple of judges say, you know what, just write at the bottom there, no problem. Just write, I want this information in the warrant because I ask you that and I think it's important. Perfect. The judge is helping me be better. We're not trying to hide anything, and we're making the warrant more accurate. That's not a failure. It's just a pain in the butt to go back and reopen a warrant, change the warrant, maybe go back and find the DA and have him re-sign the document. I wouldn't do that. I would just change the warrant. I'd call the DA and say, hey, I'm adding this. I'm leaving your signature and using the original signature, but I'm adding this, and you know what's in there. Okay, no problem. And then I would go to the judge and say, okay, judge, I ordered this in here, and I call the DA, and he said he understands that I added this. Okay, great. Then the judge signs the warrant. Now we're all legal. But, again, that's just me being overprotective. The more times you get handed your butt in courtrooms, the more times you don't want that to happen again. So you do things like I'm explaining to prevent that from happening. Okay, search, the investigation being concluded. Nighttime service is being requested. It almost seems like, because this is ongoing and these were done, I can understand a lot of nighttime service warrants, because this was just a crazy incident. And you had victims continuing to come in. You had new information coming in. You had multiple agencies, multiple jurisdictions. You had multiple victims. You had multiple, people, different cities, different jurisdictions, Arizona, Nevada. So this was a monster of a bucket of case. So getting a nighttime service on all your warrants was probably a good idea. And I would put in there, because it's such a massive ongoing investigation with multiple jurisdictions, multiple states, and multiple agencies, sometimes we may be doing warrants after the allotted time, and nighttime service is going to be needed to keep the warrant, to keep this investigation fluid while we're trying to determine whether there's outstanding suspects, or while we're trying to determine whether there's more incidents that may be coming, or this is one incident of multiple incidents. Those are things that you want to articulate to the judge and to the defense attorney on why you're doing what you're doing. This blanket, I want every warrant sealed and I want every warrant nighttime service, without making it clear, to me, isn't within the spirit of the law and is incorrect. All right. So now we get back into who's saying what. Let's see. So then he finishes. The judge says, Judge, do you find probable cause exists for the issue of this warrants? The judge says, yes. Judge, the judge says, yes. I do. I think what the cop probably said is, do you find? He repeated it. And the judge said, I do. Because she said yes, and he wanted I do. Okay. Judge, do you authorize the search warrant to be sealed? Yes, I do. See, to me, especially on a recorded thing, the judge should be asking questions. If I can sit here and ask all these questions about the warrant, are you telling me a judge on the bench that's been through law school, has been an attorney, and is sitting on a bench approving search warrants, he can't come up with the same questions that I'm coming up? I call BS. To me, this is where you get into these rubber stamp search warrants, to where the judge knows the cop knows the judge, whatever they say, yeah, let's go through the motion. Do you all? I do, yeah, I authorize, no problem, go forth and search and destroy. And boom, it's served. I don't like that. That's just me, my constitutional side, my right side, my doing things the right way, my having a check and balance with the DA. This is how you get crooked DAs, crooked judges, and crooked cops working together. Everyone should be held to a high standard, and you should hold yourself to a high standard. As a cop, I don't want the judge asking questions, but I want to make everything clear and above board. As a judge, I want to make sure I'm holding the DA and the officer's feet to the fire. As the DA, I want to make sure the officer's feet held to the fire and the judge is signing a good and valid warrant, because I know there's lazy judges. Everybody has a check and balance in a warrant system, and when people get lax and lazy and they start rubber stamping shit, that's how things fall apart, and that's how you get corruption and backdoor deals and BS. I've seen it. I don't like it. I've been a part of it. I don't like it, and I've been on the receiving end of it. Okay. The cop says, thank you. The duplicate warrant will remain a search warrant, blah, 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 blah. He goes through his standard statement, and the judge says, good night. The transcription has been typed, blah, 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 and is signed. So this is basically a transcription of how it went down that night when the officers talked. Now what are we doing here? This return search warrant. So on the return, what did they find when they did the search of the Las Vegas room? This is where it really gets interesting on the things that they seized. They seized a lot of items, and the numbers is what gets me. Okay, so we got 21 rifles with magazines, 2 rifles without magazines, 1 handgun, 114 magazines, approximately 5,280 live rounds. So he had 5,000 live rounds. That was never released to the media. Casings. We had 1,050 casings. So all this time they're saying he fired over 1,000 rounds. How did they get that 1,000 rounds? Well, now we know. They found 1,050 casings. So therefore, a casing is usually an empty bullet that's been fired. He fired over 1,000 rounds. So he looks like he brought 5,280 live, 1,000 fired. That's how many rounds he brought to the room. What else did we have? We took hairs and eyelashes. We took sandals. We took gloves, napkins, clothing, receipt. 54 towels. Why did they take 54 towels? He might have been using towels as a muffling device. They wanted to get DNA from the towels in case people were taking showers there to know who was in a room, who took a shower. They're going to take DNA samples from all those towels and find out who used them, what were they used for, is there powder, is there oils, DNA, hair, etc. So that's why they took the powder. To me, what they're seizing in a warrant says a lot about the investigation. Okay. So they took a box, handwritten notes. So now they can compare the handwriting, make sure he wrote it. Trash can contents, anything that he threw away. A lot of times people will throw away notes or things or food, or someone else come in and throw away a Diet Coke can or something. You want to take all that because you can get DNA from all that, and you can put people in the room that say they weren't ever in the room, and then you get other suspects and other leads. They took forks, probably for DNA. They took coffee mug, probably for DNA. Vitamin water bottles, portable water bottles, bedding. They want DNA off the bedding. Did he sleep with somebody? Is there multiple? Is there human fluids? Phone adapter to see what phone does it fit. If you have a phone adapter that doesn't fit the phone that you seize, that will indicate that somebody else was there charging their phone, or we're missing a phone. We got an adapter, but we got no phone for it. Why did somebody plug in a phone adapter with no phone? Where is that missing phone? What phone does that attach? Later, when we get a suspect and he has the phone that fits this adapter, we'll be able to connect those dots and say, hey, we had an adapter to your phone in this room, therefore you were in a room, and we had a towel with your DNA, and we had a Coke can in the trash that we took with your DNA, therefore you were in a room, and now your phone was in a room. So now that's how you connect. That's why when people say, you don't need to take that, you always want to take more at a crime scene, especially on a homicide. You take everything because you just don't want to screw around. It's serious investigation. On a regular, if I'm involved in a domestic violence, am I going to take the trash can? No. But on a homicide, absolutely. Phone adapter, power supplies, cameras. Obviously, you want cameras for film and, or SD cards. You may find an SD card later at his house that fits this camera. If you have the camera, you can connect those two dots. Let's see. Gatorade bottle, miscellaneous papers, flashlights, suitcases, long gun cases, personal messages, drinking glasses, a spotting scope. Move over to second aisle over here. Ball in a package. 6-inch foam ball in a package. Not sure why they took that or what that is. Refrigerator contents. Okay. You can tell what he's eating or what he's been eating, or if somebody else was eating something. A black camera. A drill and drill bit. Why did he bring a drill and drill bit? Was he hanging? Maybe he drilled through the glass. Maybe that was how he broke the glass, because that glass is very hard. Maybe that drill bit drilled through the glass in order for him to break it. Took the fire extinguisher. Maybe he had it next to him in case there was a fire. Maybe he had a fire in his room and he put it out. I don't know. An LED screen, a wallet, contents. Obviously, you want to take his wallet and contents. Bay key cards, binoculars, a baby video monitor. Remember they said he set up monitoring devices in a hallway? He got a baby video monitor. He set one of those in the hallway. That's what he was using to monitor the hallway. Wasn't rocket science. They made him look like he was this high-value, conspirator, been playing this for 20 years. He got a baby monitor and video, and he set it in the hallway. Okay? It's not rocket science. But you wouldn't know that, but now that I'm seeing things, again, when I see search warrants and what they took, to me that tells me a lot about the investigation, because I'm looking at it from kind of like reverse engineering here. If they're taking this, they obviously think it's involved. If it's involved, this is what they think the crime is. A peephole, a handgun holster, a phone charger, valet parking receipt. Obviously, they want to connect his receipt on where. That's probably how they found the car. They found the receipt and said, oh, shit, he's got a valet parking receipt. Let's go check to see if the car's still there. Holy shit, there's his car. Holy shit, in the car's tannerite. Wow, now we got explosives. So that's probably how they got there, and that's how an investigation progresses. An L-shaped bracelet. Not sure what that means. $273 in cash. Casino vouchers. Bear mug. Door flame lighter. He had a lighter in there. Maybe he had a fireplace. I don't know. He had a fire extinguisher and a lighter. Maybe he's a smoker. Clothing. Duffel bag. Let's see. It looks like there's a couple more things at the bottom here. Duffel bag. Home security system. He brought in a home security system. Battery. Suitcase. Another lighter. Drill bits packaging. So he may have went and bought the drill bits. Towel. Something, a screw bracelet. I can't tell what that is. Video monitoring camera. A phone charger. TV bling with snorkel. What? Funnel fan. I'm not sure what that is. Miscellaneous tape. A hammer for break-in. A box cutter. Glasses and spotting scope. Okay, let's move down a little bit further. What else are they seizing? Again, what they're seizing tells me a lot. Okay, so what are we seeing here? A blue dive bag. Maybe this guy was a diver. It's a waterproof bag. Maybe that's how he brought things in. The guns probably fit in that dive bag. Glass cutter. He brought in a glass cutter. Miscellaneous locks. Why did he bring locks? Was he locking doors? A Bushnell, accessories, containers, empty. I can't tell if that's a magazine. Yeah, magazine. 7.62 by 51 magazine. Empty Surefire magazine. 7 empty 7.62 magazines. The Surefire mags, I think, were what? The 30 or 60 or 100 round mags. Green suitcase, brown suitcase, passport, checkbook. Checkbook will, you always want to take checkbook because now you have his bank account information. You can do a warrant to get his debit cards, etc. So checkbooks will always get you into other things. Gift cards, casino vouchers, folders, miscellaneous. What is that? Condoms? I don't know what that is. Columns, notepad. Move over here. Drill, butter knife, hairs, towels, another towel, glassware, hair dryer, remote control. Get DNA off the remote control. Who used it? What were they watching? Did it connect to the TV? If he bought some prepaid stuff, if he checked his email on TV or accessed the internet, the remote control will have his DNA. It will also show that it's connected to the TV. That may be important and may not. But again, you want to seize everything that could later possibly tie something in there. Foam, towels, wall board, phone, charger, TV remote, curtains. They probably took the curtains because there was gunshot residue and maybe blood splatters on the curtains. Can't tell what these are, handwritten, not real copies. Sprite can. Obviously, they want DNA or fingerprints off that. Miscellaneous medications. Laptop. Okay, so they seized, obviously, a bunch of stuff from the room. TV remote, black phone, I can't read that, cutlery. Again, I have this document on my website. I'll put a link in the description. And I'm only on page 43 of 141. I'm an hour and 51 minutes. So I'm just going to skip to these returns since I've kind of already done this, and we'll look at all the evidence that they received. They got a radio, a Garmin tool, let's see, bear bottle, gun, suitcase, seat belt, fiber. Maybe there was blood on a seatbelt fiber. Black gloves, rifle, tannerite. So this must be the search of the car. I didn't look. Let me go back, be sure. Yeah, okay, so they searched the car, the Pacifica Chrysler. So these are the things they took out of the car. Black bag, 2 jars silver, can't read, glasses, tissue, shopping bags. You always want, when you're searching cars, you want shopping bags because a lot of times it'll retain not only fingerprints if they went shopping with somebody, but it normally retain a receipt on where they shopped. It also tells you where they shopped so you can go back to the store. If he's got a Kroger shopping bag, I can go to Kroger, I can pull their video, I can see what he bought, how he paid for it, who was he shopping with. These are all important things. People might say a shopping bag, why do they take that? Those things are important, and if you get a receipt, it's really good because now you can get a receipt. He went through McDonald's drive-through at this date and time. He bought this amount of food. He paid for it. This is how much it costs. And we can go back to McDonald's, see if they got video footage. Maybe we can see who's in the car with him when he drove through there. So this is how investigative things go. When we're seizing things, we're actually seizing hints or clues that are going to lead us to other areas. And again, if I was doing a search warrant for the videotape at McDonald's, I could say, I received a shopping bag, and in it was a receipt from McDonald's to where he purchased so-and-so at this time. It was found at the scene of the crime, and possibly the suspect used this at this date and time, and I want to know who was with him, etc. Therefore, I need a search warrant to seize all evidence, video evidence from McDonald's for the time period of blah, 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 blah. And now I'll go there and I'll serve them with a search warrant to seize that information based on a receipt or a shopping bag, because that will be my probable cause. Let's see. Clothing, documents, doors, blankets, filters. All righty. Moving along. Anybody still here? If you're still here, raise your hands. All righty. If you're still here, slap a liberal. Woohoo! All right, let's see. Search warrant 79 C&D Order B. All right, what the hell is this? Upon XA, they just go through the order. I'm not going to read all this again if I've already read it. Northern Nevada Center, 20 years. So this is a different guy. He's been on 20 years, and he's been on the task force for 1 year. Man, this blanket, I'm just a cop, therefore I'm qualified, is amazing. Based on the information investigation, detail 3 attach applications and finds 2 other search warrants. So this is a piggyback warrant on 2 other search warrants. Let's see. Your affiant request warrants, 3 search warrants sealed, probable cause. What are we searching for? Additional evidence, mode to code spirit. That's where the sealing. Exhibit 1, copy. So now he's just putting copies of all the other warrants. I thought there was something in here that I wanted to confirm, but oh well, you get the gist. Anyone else that wants to read through it, I'm almost at 2 hours. The complete search warrant, and again, this is just one of the search warrants. There is a second warrant. That's him. This was Las Vegas shooting search warrant 1 that I just opened. On my side, I have Las Vegas search warrant 2. If I click on that, that's going to be more search warrants that they've unsealed. And I think these are basically the phone warrants. So this is how we go to get cell phones and phone numbers and who they called and all the texts, etc. So if you want to look at the difference in a search warrant for cell phone departments, this is basically the different search warrants on cell phones. And this is what they tell the cell phone company we want. We want subscriber information, who described it, where he opened it, and how he got in there. Records of incoming, outgoing calls, incoming, outgoing SIM messages, records all data sessions, data activity, locations on where it was at. So this is a standard. Anytime you get a cell phone warrant, you just cut and paste this in here, and most cell phone companies know this is what you're going to ask for. They have a program or something, they can pull all that up, and it'll be sent to you pretty quick. But if you want to review the search warrant, this is another 177 pages of documents on the different search warrants that they did. So if you really want to know the case and you want to know what the cops, you review their search warrants, and you will understand pretty quick on what they know, what they're looking for, where the investigation is going, how it ended up, what the officers are looking for, what they took from the premises, etc. And I don't even know if I went all the way down through this. Let me go to the bottom of this and then go up. This is a return search warrant here. And black, maybe black vase. And I can't tell what that is. I don't know if those are just pictures or something. Sometimes I'll attach a picture of the evidence when I do a return search warrant for the judge so he can see what his warrant got. Anyway, a lot of 177 pages on this second document. So again, if you want to go to my Think Like a Hoss, I'll put a description, as a matter of fact, to both these links in the video at the bottom. And I'm at 158 minutes, or an hour and 58 minutes, and I'm getting hoarse. I need to finish my coffee. All right, we'll end that there. Hopefully you got some out of it, this investigation. To me, I learned more from these search warrants than I did from 6 months of the crappy reporting and no investigative reporting, and nobody came back and did a warrant, read these warrants, and have done, a report on this case with all this new information from this warrant. If I sat through and went through this warrant line by line, I could write one hell of a press release on where this warrant is going and what the cops knew and when they knew it and what they have. And how this case should, this BS about, we have an ongoing investigation. This investigation ain't going. Looking at these warrants, this investigation is pretty much over. It ain't going nowhere. They're not looking for anybody else. They need to move on. But my opinion, take it for what it's worth. Don't be giving me hate from Nevada because I cracked on your weak hero sheet or you left out a few things in a warrant that I think would have been important. We'll end that there.